Employers. I expect many of you are wondering what to do in light of the current noise and fuss about whether or not transgender women can use female spaces. There was a lot of misinterpretation of the Supreme Court ruling, and now that we've had the determination in the Sandie Peggie v. Beth Upton case, we've got some real clarity on what the law actually is to be interpreted as. Because also just remember that a court case is an interpretation of the law. It isn't the law. So there may be different types of interpretation, but it's important that we understand what the law says. And the Equality Act is very clear, and it says we mustn't disadvantage people on the basis of their protected characteristics. So we mustn't disadvantage women more than men. We mustn't disadvantage transgender people more than cisgender people. It's not about the advantages of cisgender women v transgender women. They have the same rights. What it is are you disadvantaging women over men? Are you disadvantaging transgender people over cisgender people? So the outcomes for employers are very clear from the Sandie Peggie case. Trans women can lawfully use female-only spaces at work. Phew, that's something that we all wanted to understand and hear. A female-only sign on the toilet door or on the changing room door doesn't mean cis females only. It doesn't mean biological females. It means females, women, and transgender women. Neither set of rights comes first, and I explain this more on my Substack, but the rights of everybody are equally important, everybody. Gender-critical beliefs, you're allowed to have them, but just be careful what you do with them. We've seen several cases go through the courts recently. Linehan was one of them. It's okay to have your beliefs, but if you're going to stand on a great big podium and start shouting them, or if you're going to make other people's lives unpleasant or miserable because of your beliefs, that's when you're going to run into trouble and actually be held up for them. Cis women can object to trans women using female-only spaces, but it's only an objection. It doesn't necessarily need to be acted upon. You've got to do your own risk assessment. Is it affecting the majority of cisgender women? Is there something else that the cisgender woman could do, like go to another female space? Her, not the trans woman, her. Is excluding trans women a proportionate thing to do? Do you have to do that in order to give everybody somewhere to go to the toilet and somewhere to get changed? Which is going to hurt more people, inclusion or exclusion? Which is going to hurt anybody at all, including people or excluding people? Because if there's no evidence that anyone is going to be hurt or disadvantaged, you don't need to do it. Have you got a policy? Have you got a trans inclusion policy? Have you got a sex-based equality policy? Because remember, we're talking about the sex characteristic. We're talking about giving the same advantages to men and women. And the gender reassignment policy is we're giving the same advantages to people who have undergone gender reassignment and people who haven't undergone gender reassignment. We're not comparing trans women with cis women. Employers, what is your process? What happens? Do it now. Have your meetings now. What are we going to do if we have a cisgender woman who comes and says, I don't want transgender women using my female space? Mock it out now. Where's your policy? Where's your response in writing? Where are your templates? What's your course of action going to be? How are you going to interview the person who's raised a complaint? How are you going to respond? What are you going to do to analyse and assess his or her concerns? Mock it out now so that you have it, because what we've seen in these cases is that the delays cause problems, and that's why Sandie Peggie did one on some of her claims because of the delays, because the hospital didn't know what to do, because the hospital didn't have a clear policy, they didn't have a clear process for what would happen if someone raised that kind of complaint. Really important. And finally, document everything in writing. You know, if and when this was ever to get to an employment tribunal, prevention is better than cure. Make sure you've got that policy, make sure you've got your process flow, make sure you've got staff training, make sure staff understand what the policy is and why. Make sure you've done an assessment of risk for everybody and everybody's rights and everybody's protected characteristics. Is there somewhere else someone could go to the toilet if they wanted to? Do you need to change some signage on the doors to give someone who might raise a complaint a different space that they can go to? And then document everything. If you're going to get to an employment tribunal, you want to have the documentation really clear. Imagine the judge looking at it going, right, we've got a very clear policy. We had staff training. All new staff and existing staff signed up to the policy and were asked and invited and made to go to the training. There was refresher training. We have a clear process when complaints are raised, and we stuck to that process. And this is why our policy said this, because we did this equality assessment on all of the protected characteristics, and all we wanted to do was make sure that the toilets and changing rooms were accessible and inclusive to all. And that way your employment tribunal won't be 300 long pages. You won't end up with a negative adverse outcome, and your employees will be safe and clear in what they need to do and where they go to the toilet and where they get changed. I really hope that helps. My Substack goes deep diving into these issues, and I welcome you to meet me there, subscribe and share your views.